Morning.
Good.
Jim. How are you? Feeling better?
Yeah.
Somebody's hanging out.
That's a similar answer. I could answer that the same way.
Okay, so I'm back. You guys tabled the request. I don't know if you had time to talk to Tim Reed, who I think's been advising you on this matter.
We have. So
So what are you gonna do?
we'll I don't know whether you want to mention if there needs to be any discussion. The discussions that I've had with him, and actually it's been Jim Budson. You know Jim?
Mm-hmm.
With them in their office apparently Mr. Reed has been off an issue, but the approval, the recommendation, even though there was some thought that it wasn't necessary, was to go ahead and approve the attorney through the hearing process. There doesn't appear statutory reason beyond the hearing process, through the hearing process. So, if the other two members are amenable to that, then that's, I think, what we're going to do.
I think that, you know, I got an opportunity to talk to Tim Reed directly after the meeting because it left me with a lot of unclarities as far as when we, you know, sat down with him and went through all of this. Never were we advised that this was a situation that would have developed into this. I think bottom line is we had, I'm not going to say bad advice, but I don't think we received the full picture of what our options were or what the, you know, repercussions were going to be as far as the whole appeal process, or the possibility for appointment of special counsel and all of this. So, you know, I pretty much, you know, regurgitated this since last week, and I can tell you that my position on this is that I'm a little bit agitated with the fact that the right thing was to, you know, remove both of these parties because of the fact that I think that if you look at the situation, it's pretty evident that something, you know, should have been done. I would hope that they would have just, you know, stepped down with what's at play. So as far as I got to put two hats on, and I got to look at this as what's fiscally sound and responsible, and what's the, you know, what other options are there to do, and looking at the situation that both of these parties are going to be up very shortly as far as their appointment, that I could assure that I would never, you know, move to appoint either one of them back on this as that role because of, you know, this past history. But my position is this thing could turn into an absolute money pit, and you know, and I think that you would probably agree it could, and I think that at this point in time, I would rather move to send the message that, you know, we've been made aware of what's going on there. Taxpayers know, because a lot of them have come to us to say something needs to be done, but it is to be fiscally sound and responsible for tax dollars. I think that my position would be is to rescind the motion and move to just rescind our motion of dismissal and just get this to the point where we can get back on track and take a fiscally responsible position. I think that we've sent a message. I don't know what the other people agree with or don't.
I mean, we have to vote yes if we're going to continue down this path to hire counsel, because it's the law. If we don't, then Jim will go across the street to the county police court, and then they'll file some kind of, I don't know, legal jargon, but they'll file something that says we're not doing our job. So we have to do that. I've never been from day one in favor of this, because the level, as I see it, we have other people on that board that are as guilty of some of these charges as some of the ones, and now it looks like it's, I don't know, you're singling someone out. And I think I said the last time this was at this table, that the problem will sort itself out shortly. I believe the newspaper, there was an article that said their term, one of the papers, expired in 2021, which I don't think is correct. I think it's next June. Isn't it the end of June or something like that? And time this thing comes to a head, you're looking at 8 months. I don't know what the cost per month will be to get them out earlier, but it's going to be more than I make.
Let's base this on some reality here. First of all, what we've spent on an attorney on our side is what we've spent so far. It's a few hours for consultation in terms of how to proceed with this. Going into the hearing process, after the hearing process is over with, that legal fee will end. So we basically have already spent what we're going to spend, with the exception of the process going into the hearing process.
Is a lawyer telling you that the legal fees will end, or are you saying this?
No,
I want to.
this is an attorney telling you.
Okay, because I don't agree with his assessment, by the way.
Okay.
Did he tell you that they would have the opportunity to appeal an administrative ruling to common police court, take an administrative appeal?
What he told me was that there's no statutory process to take this beyond the hearing. There is nothing in the state law that...
He doesn't believe that they could take an administrative appeal to common police court?
He doesn't, that's what he told me, yes.
Okay.
And so, and with the except...
I wish he was here.
With the, well, me too. We can call him, maybe we can have an executive session and we can have that conversation with him. I would love to have that. But let's assume for the sake of argument, that he's correct. That we're going to go into a hearing process. What I was told yesterday was that if we approve this, number one, we're not paying for it. This is coming out of the mental health board budget. Granted, taxpayers are going to pay for this. But there is an obligation on the part of this office to do our duty with respect to those things in the law that we're required to uphold. It is very clear in the bylaws in the Ohio Revised Code with one individual that if you don't meet certain situations, that they are required, the mental health board, which they have never done, to notify this office to vacate that position. We should have used the term vacate rather than remove, because that's what the law indicated that we have the right to do, and I think it has different legal basis. But once we go into the hearing process, which we're going to be, if we stay on that track, we'll be sending out the letter probably for next week to go through the hearing process. And at that point in time, if he's correct, and in one case, the law is crystal clear on our right to be able to vacate one of those seats. There is no ambiguity. We have a right to do that. And the mental health board had an obligation to tell us about that situation. And we need to inform the mental health board of their legal obligations in that matter. So that going forward, they're doing what they're supposed to do. The reason we are here is because there are some things going on in the mental health board that they're not doing properly. It is our duty to make sure that board is performing properly. We put people on that board to ensure that. If that's not happening, then it's our job to correct that. So anyway, that's relative to the budget and to the financial side of this. What I've been told is that there is no statutory purpose beyond, this is an administrative action, not a legal action. We have a right administratively to deal with this administrative situation with these people. And then beyond the hearing is where it should end. Now, I'd love to have Jim have a conversation with Jim Budzik and or Tim to confirm that, because that would maybe alter the situation here. But again, my understanding is this will end with the hearing process. Once we've made a determination in the hearing, it is what it is then at that point in time.
My conversation with Tim Reed was different than that, because I specifically asked that question. So I don't know, I haven't talked to Budzik, I don't know who he is. So I talked to Tim Reed directly after we got done. I had a conference call with him and Dave Blair in the office. and I specifically asked him, where does this go as far as this? And basically, I point blank asked him, I said, if they don't like what they say there, can they? And he said yes. So at the end of the day, I'm not saying that you're wrong, but I know that what Tim Reed said to me was now all of a sudden, yeah, with that this can go on. And you know something? I am not really I am not going to see a muck of money like what the mental health board spent on us making simple public information requests. I think what needs to happen is the general public needs to wake up and see what the mental health board and what that mental health department is actually doing with the money that they're paying into the levy, when it should be going to support the cause and the needs for mental health, but rather it's playing games like this. And I'm not in a position to put tax money, ahead again to be able to start another legal process to basically, throw a whole bunch of money away to a legal thing. And I'm not. My position on this is I would ask to put a motion forward to say we rescind this. June will be here before you know it, and it's done. And I think that the message has been sent. The public has been made aware of the improprieties that they have that there are in that department that I have been preaching from the probably the second year that I've been here as commissioner, and it needs to get straightened out. But ultimately, we cannot be the fix-all to everything. Their board needs to take action where it needs to take action. I think they need to pull up their bootstraps and get to work and create the right direction for that department that I think I know what I would do. But at the end of the day, I think that my position on this is I would make a motion to rescind that and move to rescind that.
That
That's
creates
your motion?
That creates one problem for this board, because we have a legal obligation under their bylaws to take action on one individual. We can't avoid that legal obligation.
Now, who says you have a legal obligation?
Read Ohio Revised Code and the bylaws on the paragraph on.
Well, I know there's attendance requirements, but
There is an attendance requirement.
That obligates you to act through an administrative process? I missed
That
that section of the revised code.
If you read that paragraph, it says that the board shall notify this. That doesn't mean that they have an option there. They shall notify this board for us to take some action. So we either have to say, yes, we're going to take action, we're not going to take action, whatever the case is. We send out a letter now indicating we wanted to vacate that seat based on attendance schedule. And by the way, it is irresponsible for us to have somebody on that board that is not showing up for meetings. Their purpose in appointing people for that board is to be there. We've got a vulnerable group of people we're making decisions for. And if we don't have people who are stepping up and doing the responsible thing on that board, it's the obligation of this board to make a corrective action on that. I'll make a second or a counter suggestion, because all the information that
I
I've
have a
got.
motion on the table. I haven't seconded it, but because you started to talk. But if Mr. Spitaleri has made a motion to rescind our action from the whatever meeting that was 2 meetings ago, or I don't have the date. If he's making a motion to rescind that action, I will second that.
Okay, then we can have discussion. So continuing in the discussion mode, I'm going to make a amendment to that motion.
Wait a second.
Mhm.
There's a motion on the floor. You can discuss the motion on the floor and act on it, then you can entertain.
I can discuss an amendment. We can amend that motion.
All right.
So another alternative to simply voiding this action is to, we're basing this decision based on misinformation and misalignment of facts. Let's get our two attorneys together, because what I've been told is this, from a legal cost standpoint, this is not, it is where it is. We've already incurred some legal fees. It's not going to be much more than that. And the legal fees from the hearing perspective are going to be now a few $100s probably, because.
And just, I'm not advising you guys on this.
No,
It sounds like you have two different lawyers who've given you two different pieces of advice.
Well, and I'm surprised by that, because they're talking.
I mean, in my opinion, as a lawyer, I think what Tim Reed told Ralph is correct, and what Jim Budzik apparently told you is incorrect. But that's just my opinion. Like, I'm sure any lawyer will tell you that With most of these legal questions, especially in more uncharted waters, which is where I think you're going with this, you get 5 lawyers in here and you're going to get 5 different answers. So I don't know that there's a right answer until a
But
judge tells you what it
the
is.
challenge I have with this, Jim, is those two guys are supposed to be working together. Jim is filling in for Tim in this situation, and Jim told me yesterday he was talking to Tim. And so, at the end of the day, we're going to be making a quick decision based on maybe misinformation. I'd rather have all the information to make a sound decision on it.
Before
So-
you came here, Skip, our predecessors, not at this table, but one like it, and I mean before you came to the county, our predecessors took umbrage or an exception with Mr. Simmons, who was then the sheriff of the county, and I don't have an accurate number, in excess of $1 million. I mean, I heard as high as 2, but it's an urban legend. I know it was in excess of 7 figures, was spent, and the attorneys that were involved smiled graciously, and the taxpayers in the county got the dirty end of the stick. And I don't see, outside of some personal gratification, what the advantage is to having this fight when it can resolve itself without cost in June, and with regard to the fact that something wasn't done correctly. If we had time, we could find numerous things in the county that weren't necessarily followed to the letter of the law. Our responsibility is, when we find them, to point them out and correct those issues, not to rub someone's nose in it. It's just if there's been an omission, if there's been something like this, fine, bring it to their attention. If they don't follow the rules, then, well, shame on them. But as far as moving forward on this issue, I suggest we call the question.
Well, let me make one more comment before we do that. Again, the last person on this table who wants to spend a bunch of legal fees is me. And I'm told, based on what I've been hearing, that that the likelihood of that occurring is not that great. Because, again, we've already invested what we've invested. We've already used an attorney for counsel and so on and so forth. I'd love to hear what he has to say regarding Jim's comment, because, but...
Skip, I had Dave right there with you.
Yeah, I mean, if I could, I don't remember the specifics, but I don't remember him categorically saying that there's no way they could appeal that. So that would be, I mean, but that appears to be what you heard from Mr. Buzz.
Well, and you were there, you were on the phone with
Yeah.
him. And
Well, and that's
Jim,
what he, yeah.
Jim indicated, and again, this wasn't just me, you heard.
Yeah, I heard
I had
that
you
too.
on a conference call.
I heard that too.
And he indicated that the hearing process would be the end of it, because there is no statutory mechanism to go forward out of the hearing. It is an administrative action. We thought it shouldn't be at this table based on what Tim originally told us, because this is an administrative action, not a legal action. And so we've turned it into a legal action for some reason. But, if we're making a decision without all the information, I'll go along with you two if you want to just pull the plug on this. But it's unfortunate, because we do have a duty to ensure that things are done properly, and we're just avoiding our
Well,
responsibility.
to that point, if I could, I'm reading this section that's applicable here, this 340.02, in the last paragraph that I think was in the letter. And it says, upon absence of a member within 1 year from either 4 board meetings or from 2 board meetings without prior notice, the board shall, that's the mental health board, shall notify the appointing authority, which they didn't do.
That's right.
The final thing is, the appointing authority then, which may vacate the appointment and appoint another person. So it's not a legal requirement that you do so. You may, but you're not somehow missing your legal responsibility if you don't. I just want to make sure.
That's a true statement.
Yeah.
And nobody so far, other than the individual in question, has missed the requisite 4 meetings. We've got some people that are on the verge of that, so we need to send notice to the mental health board about that situation. But that gives us the opportunity, the law is clear that we can remove one individual because they haven't attended the necessary meetings. And why is that important? Is that because we want to rub their face in it? No. It's because we need good people on that board who are going to show up for the decision process. We have vulnerable people that they're making decisions on. If we don't have people showing up for meetings, those vulnerable people are not getting good decisions. I've got a concern about that. It's our responsibility to ensure that we have got responsible people on these boards making good decisions, and that they show up for meetings to make those decisions, and that the decisions that they're making are those things that they're doing. I mean, with the other individual, there's some real concerns that I have over some of the decisions that this person is making and defending on that board. And so we do have some responsibility there. If we want to step aside and kind of poo-poo that, then fine.
I mean, I just got to tell you, I really, I'd love to get your permission to talk to Jim Budson, because I mean, I'm looking at revised code 20, I just pulled up.
You certainly have my permission.
2506.01, appeal from an agency or of political subdivisions. Every final order, adjudication, decision of any officer, tribunal, authority, board, bureau, commission, department, or any other division, political subdivision of this state may be reviewed by the Court of Common Pleas of the county in which the principal office of the political subdivision is located. I mean,
So
the administrative appeal section of the revised code is so broad. I mean, that covers everything.
So let me ask you this, because I don't know. I'm not an attorney, so and I don't understand all that. I have to lean on.
Again, I'm not advising you on that.
No, I understand.
I'm not giving you legal advice on this. I'm just.
But what you just read is if in a legal situation there is a finding, we can take that to the court.
This is an administrative proceeding. You have to afford somebody due process rights. They hold a position on a board.
Mhm.
They hold a public office in the county. You, through an administrative process, are going to remove them from that board, from that, and take something away from them. They have the right to appeal that to court.
What are we taking?
It's called. I thought you had the Constitution all over your office. It's called due process.
Of what value? I mean, I'd love to reach out to Jim, because I'd love to.
The issue here, when I first came on the commissioners, there was an action taken, which I disagreed with. And I still think constitutionally I'm correct. And we hired an attorney, and we proceeded with this issue until it became obvious that we didn't have the votes anymore to prevail. And that issue had generated some tax dollars to be spent on legal fees. I was really upset by that. And I instructed the finance director and the administrator that when that bill from that lawyer came in, I was to get it. And who's counting, but it was $3,305 out of my pocket, but nobody's keeping track. And I wrote the check, personal check, to pay the attorney so that I didn't incur a debt that the taxpayers had to pay. That's not a hooray for me. That's more a when a lot of times when we make a bad decision, someone pays for it, but it's not us. I think this is a bad decision going forward. I thought it was a bad decision for the whatever number is 34,000 total or something that was spent of taxpayer money, regardless of whether it came from mental health or it came from the general fund. It wasn't my money, a portion was, or Ralph's money or Dave's money. It was our money. And I just think when you get burned, don't stick your hand back into the flame. Just, that's enough. And I had already called the question, so, and if you forgot what the motion was, I think Ralph made the move to rescind that action. move on or something along that line. Is that correct?
Yep.
I don't want to speak for you.
First of all, should we read the motion on the agenda to be either approve or disapprove of the
No, I'm gonna,
appointment?
if they pass this, I'm gonna withdraw the
You're going to
request.
withdraw, okay.
Because it'll be moved.
Okay, the previous motion was to approve and execute letters to Mr. Ceason and Mrs., is it Randazzo? Okay, notifying them that the board, the county commissioners will be removing them from their position. So,
The
we're not
motion here
really-
is an action to rescind that.
We're rescinding, weren't the letters already sent?
Yes,
So we're not rescinding the motion to send letters.
that's true.
Rescinding the board action to remove those two members.
Yes.
And we can send out letters advising.
Somebody with more education than I needs to word that properly, but
Debbie's doing great.
that's
Okay,
great.
so-
Well, she's got more education than I do, so.
This isn't over. Let me finish.
Oh, wow. Now you tell me, Sonny.
Okay, so the commissioner's office, let me see here, is requesting the board to rescind? Not-
Rescind the action.
Rescind the action to remove Mr. Ceason and Mrs. Randazzo from their positions of Jog County Mental Health and Recovering Service Board. Is that okay?
Perfect.
Okay.
Yep. And we have a motion and a second.
Second, okay, and then,
Aye.
okay,
Aye.
okay.
No.
Well, based upon the board action, then I will rescind the request for the appointment of outside legal counsel for those board members. So, I thank you. I don't like being stuck in the middle of this stuff. And as a taxpayer, I appreciate your comments, Ralph. The easy thing sometimes is to fight, and the hard thing sometimes is to be good stewards of the taxpayer dollars. So I do appreciate your comments.
Tim, do me a favor and reach out to Jim for future reference, so that as we're trying to think through these decisions in the future.
Yeah, if you guys are okay with
It
me
would
talking
be,
to them.
yeah, I'd love to, because we need to make decisions based on real information, good information. I do not think we made a good decision today based on good information. We should have gotten back to the attorneys to get good information, because we do have a duty and a responsibility to do the right thing, and I think we avoided that today. We don't have a spine sometimes, and sometimes you have to spend some money to do the right thing, so.
Yeah, I mean, I'll be happy to talk to Jim. I mean, Jim's a very good lawyer when it comes to employment issues. We've consulted with him in our office on a couple of pretty tricky employment issues that have come up. I mean, he's a good lawyer. But concluding that they wouldn't have had administrative appeal rights to county
Yeah, I'd love
police
to- I'd love to
is
hear-
bizarre to me personally. But
I'd love to hear,
I mean, I
you know,
think
what
what
the outcome of that is.
Tim told you, Ralph, is I would agree with. So, and, you know, that could have been a pretty hefty bill at that point, because you could appeal that all the way up to the Ohio Supreme Court.
again, I was basing my decision based on what I was hearing, and I'd love to hear if it's something different, because, you know, again, that could come into future decisions, so.
Yeah, I'll call Jim today.
I can
Okay.
do that.
Thank you,
Appreciate it. Have a
guys.
good day.
Take care.
Bye-bye.